Morning, Your Honor. Aaron Maurice on behalf of the plaintiff.
Good morning.
Morning, Your Honor. James Jimmerson, bond 12599 after Defendants. We're also present on my left.
Right. I did get cases from defense. I did not get any from plaintiff.
Your Honor, we dropped off a binder.
Huh? Oh, yours is this one. My bad. Hang on a minute. We don't have that case now. It's a plaintiff's. So does that mean I didn't get any from defense?
No, Your Honor, we also hand delivered a copy of the 8 cases to the court.
Well, those ones they don't have. Huh?
Excuse me, 7 cases, Judge.
Well, I don't have them.
We've received confirmation from Chambers that the.
Oh, I'm sure you said, it's. Not me. But it is technically me. Look, there it is.
Let me open it up.
I can go through everything, but I gotta be honest, I'm kind of leaning towards just denying it at this point. I think. Just think it's early.
I appreciate that, Judge. The issue that we have is that because we're talking about a legal duty here, right? It's not a situation where you have to evaluate facts, including but limited to breach of fiduciary duty. When you don't have any authority anywhere in the country, including the state of Nevada, in which a boyfriend or girlfriend have been held to have either a fiduciary relationship or a confidential relationship with one another, and there is no authority from either side providing for that.
Well,
That is where the court should come down and dismiss those claims. The remaining claims, the fraud claims, the court indicated it was not inclined to dismiss. And we would still maintain the statute of frauds would prevent the court from granting relief concerning the deeding of the real property because the plaintiff had the ability to deed the property to himself or in any way that he wanted. This isn't a situation in which he trusted my client in any way, shape, or form concerning the deed or acquisition of the home.
I think we get there later on summary judgment. I don't disagree with all your arguments. I just don't think it's for now.
Okay, right. I guess my question is, there's no legal duty now, or why would we?
I think that I'm not convinced there's not a legal duty based upon the cases that I've read. I think that there arguably is. If there's a close enough relationship. I'm trying to.
I mean, when the court asks for each side's best cases,
I know.
when they don't cite to a single case concerning unmarried boyfriend-girlfriend relationship as opposed to fiancés or spouses.
Talk about close familial relationships of trust and confidence.
Correct.
Between parties.
As in son and father, right?
Well, I mean, arguably. Boyfriend, girlfriend could be closer.
But then you would think that there would be at least one case in the history of the United States that's so held. And yet there is none. We cite the decisions both inside and outside of Nevada on this matter. The closest that they get are Fick v. Fick and Cantor v. Cantor are in the same context. Fiancés negotiating a prenuptial agreement. In which case it would make sense that there would be a confidential or fiduciary relationship because they're about to be engaged in marriage and they're negotiating an antenuptial agreement. But in the context of boyfriend, girlfriend who've never lived together, who've never been engaged, right? None of those facts are pled.
No, I know.
So in the absence of that, Your Honor, the court should find that there exists no legal duty. Because otherwise you could just simply plead, oh, it's a close fiduciary or close confidential relationship and move on.
No, I mean, you couldn't. Close confidential relationship. I mean, I think if you're a boyfriend and girlfriend and you're spending time together and somebody's spending a lot of money on you and you're spending a lot of time on them, I think you do owe them a duty. I think you expect it. If I'm having a romantic relationship with someone, I expect them to be honest. I expect to be able to trust them. That just feels like different than the regular guy on the street.
I appreciate
And
that.
I feel like there should be some duty from the other side to be fair and act in good faith. And I'm not saying that. I'm looking at it more as I'm not talking about gifts or anything, but if the whole thing is, if it's kind of a sham relationship, then I think it's kind of different.
Well, and that's where I think.
And that's why I'm saying it's early, because that's a big part of what I'm looking at. I'm hearing that she actually never really was having much of a relationship with him. It was more of a using him to get stuff. Well, all the while having her actual love interest and this guy footing the bill for it.
And Your Honor, in due time with discovery, we'll be able to appropriately address that issue.
And that's what I'm saying, that I'm not saying this is with prejudice. I'm just saying I'm kind of denying it for now. You can bring it all back later and give me more facts.
Yeah, I appreciate that, Judge. I would simply, just for the record, I would want to enunciate, I think, where I believe that the differences between our position and where the court is heading. And it's simply this, that the court's expectation of honesty and being forthright, that goes to all the fraud claims. Right? That really is a duty that everyone has to do. We don't lie to them. When we talk about fiduciary relationships or confidential relationships, those are special. And so when the court,
You don't think a boyfriend girlfriend is special?
I think it depends on the
I
nature.
mean, really,
I think it depends on the nature of the
one
boyfriend.
step
girlfriend.
before fiance, which you said it was okay. And then,
Within the context of prenuptial agreements, right? I mean, the idea is there's the fiduciary duty towards one another as they're negotiating prenup. There's not fiduciary duty to act in someone else's best interest on a matter that's completely unrelated to the marriage. I don't think anyone would argue
well,
that.
I don't know about best interest. It's just honesty, I guess, not deception.
Well, and that's where the fraud claim comes in. So I think that where the court's driving at is that it believes that there's been adequate allegations to sustain a fraud claim. That is separate from the special duty of fiduciary duty, and that's where I'm really driving at, Judge, is because.
But I think when you, I think if you use someone's love for you to, it's something beyond fraud. It's something else as well. If you're exploiting someone's feelings.
And that's and that's where we're also approaching this matter from the hardball statutes, right? Which is, those statutes were designed to kick out the torts for infidelity, for criminal conversation.
All I'm saying is if she induced him to spend money because of what she's telling him in this confidential relationship, that's not right.
Well, and that's the thing, is I think that no matter what, you've got the fraud claim. But the idea being that there has to be some heightened duty beyond that. The law just hasn't made a finding that any boyfriend-girlfriend relationship where they've never had kids together, where they've never been engaged, where they never lived together. This would be the first time in the history of the United States, as far as I can tell, and I'm sure Mr. Morris has been, equally as diligent when it comes to the research. In which we
Is he right? Would I be the first one to do this? Because I don't really want to do.
He's not correct, Your Honor. What you said at the
That doesn't
beginning,
feel like a good place to be.
when you said at the beginning that this just felt early. I can totally understand that, because if you look at the cases that were submitted by both sides, I think there's only two that deal with motions to dismiss. All the rest of them were cases that dealt with either a verdict at a trial, a directed verdict after the plaintiff closed their case, or summary judgment. In each of those cases, the court had what you don't have, which is a factual record to make the determination. The one case that Mr. Jimmerson did provide the court with that actually dealt with a motion to dismiss was this Rezaghi.
Which
is
tab do you have?
This is the last case on their list. It's Rezaghi versus Rezaghi Development. It's a federal district court case. And the only reason I bring that up is because it's a rather eloquent discussion of fiduciary duty. And it does say the Nevada Supreme Court has held that fiduciary duties arise as a matter of law in certain categories of relationships. And then it provides including insurers and insured, attorney-client, spouse, fiancés, and corporate officers and directors and a corporation. And then it says in relationships falling outside these categories, Nevada law recognizes a duty owed in confidential relationships where one party gains the confidence of the other and purports to act or advise with the other's interests in mind. And here's why this gets interesting, because then the court says here, plaintiffs have alleged that Ahmed breached the fiduciary duty to disclose the bonus payment to Corey, causing plaintiffs damages. However, the court must dismiss the claim because plaintiffs have not alleged sufficient facts to demonstrate that Ahmed owed Corey a fiduciary duty. The brothers' relationship does not fall into any of the per se fiduciary relationships recognized by the Nevada Supreme Court. And I'll stop right there. I agree. This relationship
Not
does
per
not
se.
fall exactly, Your Honor. But then the court goes on to say, nor do plaintiffs allege facts indicating that Corey placed a special confidence in Ahmed, obligating Ahmed to act in Corey's best interest. Because if those allegations had been made, then the complaint would survive the motion to dismiss. Your Honor, here in our complaint, paragraphs 13, 14, 27, 97, 129, 133, 134, 171, and 177 allege exactly those facts. And again, we may be back here a year and a half from now, and you'll have a factual record to determine whether those allegations were true. That is the time to rule on to make a determination based on the facts of the case as to whether in this case, my client can prevail on a claim for breach of fiduciary duty. But right now, all you've got are the allegations in the complaint. And those allegations specifically allege that that type of relationship evolved between these two. And so again, looking kind of just what you said about it being too early, all we're here to talk about is a motion to dismiss, Your Honor. And if you accept the allegations that are made in the complaint as true as you're required to do at this point, that's enough under 12b-5 to survive the motion to dismiss.
In Your Honor, I would simply ask this court to ask the same question that the court began with asking Mr. Morris. Am I correct? And so asking, provide the case site in which boyfriend, girlfriend, not been engaged, never lived together, do not have a child together, have been found to have been in a confidential fiduciary relationship. Because that was it. I can't find a case in which it's ever been there. I imagine Mr. Morris hasn't found it, otherwise he would have cited. And that was the question the court asked, and I didn't hear an answer.
Your Honor, this kind of takes us back to the discussion we started at a few weeks ago, which was that terrible case, the Hopes versus Hammergren case. Remember the doctor, that disaster of a fact pattern? In that case, the district court grants summary judgment saying there is no recognized fiduciary duty between a doctor treating a patient. And so the district court grants summary judgment. And what does the Nevada Supreme Court say? They say, yeah, but under the facts of this case, we're going to find that in fact there is a fiduciary duty. In other words, under the specialized facts of this case. So I understand, Mr. Jimmerson, I will tell you, I can't find in Nevada this is not a per se fiduciary duty. If I had that case, it would have been number one in my binder. I don't have that case. But I can tell you, even though it doesn't fall into one of the per se categories, we certainly have allegations that, if accepted as true and ultimately if proven true, would establish the level of trust and confidence that would be required to establish the existence of a fiduciary duty. And so again, at this stage of the proceedings, that's why the motion should be denied in its entirety.
And then
I know, and I'm not sure they're gonna get there, but I'm just not comfortable with it yet. It's too early. I mean, there can be a confidential relationship and fiduciary, and I do think it's factually based and based upon, even though we don't have anything exactly on point. By analogy, there are relationships out there that can be, this may not rise to that level, but I'm just not gonna do it on a motion to dismiss.
in your honor, then my request would be that they be asked to replead to allege a breach of confidential relationship claim rather than a breach of fiduciary duty claim, because as the court just heard, and the litany of cases all substantiate this, that the per se relationships for which there's fiduciary duty are the fiduciary duty claims, and then there's the confidential duty claims. And the reason I'm asking this, your honor, is for twofold. Number one, they've not pled a claim for breach of confidential relationship. It's been breach of fiduciary duty. And so if there's
But
no,
isn't it a fiduciary duty arising out of a confidentiality?
it's actually, they're actually two separate issues, because a confidential relationship, to the extent that it's fact intensive, is one claim.
But can it result in a fiduciary duty?
I would respectfully submit to this court, your honor, that there are two different claims. There's a breach of fiduciary duty, right, for which we have legal duties and it's the existence of a legal duty, versus a breach of a confidential relationship or.
Do you mind repleting it?
I don't. What we would actually want to do would be to add those, that we would want to add two claims. We would want to take the breach of fiduciary duty claim and the aiding and abetting breach of fiduciary duty. And we would want to add a breach, it's called breach of the duties stemming or flowing from a confidential relationship. And then we would add a claim for aiding and abetting breach of the duties flowing from a confidential relationship. That's what I would propose to do. In other words, I don't think it's going to make Mr. Jimmerson happy because it's just going to
No.
add two claims for relief.
Correct.
But we've even stated in our complaint that we do believe that as discovery occurs in this case, there will likely be an amendment of pleadings to add additional parties. Generally speaking, that's, once we've done some discovery, that's when I would make the determination whether to add additional claims or to substitute in breach of the duties flowing from a confidential relationship for a breach of fiduciary duty. I'm fine either way, Your Honor.
Either way. Adding them or
Either
changing them?
whatever makes the court comfortable. In other words, if you ask me, Mr. Morris, what do you want to do today? I'd say I will file an amended pleading that will add two additional causes of action. One for breach of the duties flowing from a confidential relationship, and two for aiding and abetting the breach of the duties flowing from a confidential relationship. But if you were to tell me, Mr. Morris, I think that's the breach of fiduciary duty is a bridge too far at this point. I think you should amend your complaint to get rid of the breach of fiduciary duty, to get rid of the aiding and abetting breach of fiduciary duty, add instead breach of the duties flowing from a confidential relationship, add aiding and abetting breach of the duties flowing from a confidential relationship, and go do some discovery and see if you can establish facts.
That's what I'm gonna do.
Happy to do it.
And I would make one request then at that point, because this court asked at the very beginning or near the beginning of the last hearing we had, and that is, are we talking about matters that are just limited to the home and the improvements thereon, or are we talking about every dollar that's spent? And Mr. Morris clarified that they're really talking about the home and home only. And so either we're gonna have discovery and a whole lot of material that maybe every nickel that's ever been spent, or we're talking about home and home only.
I thought it was home and home only.
We are focused on the home, Your Honor.
So
We really are.
Improvements, I guess.
Home, it's exactly the purchase of the home, the improvements of the home. It's the home. We're not, that's why when the arguments were made about these were gifts, those were gifts, this is not a situation where we're trying to claw back, gifts. That's not we're not trying to recover a watch, that kind of thing. The focus is the home, Your Honor.
And I
I
would
mean, and I'm not prejudging, but maybe I am sort of. I mean, it seems to me that this all shakes out to be, because I think I've said before, he's sophisticated. He bought her a house. He put her name on it. He didn't do anything else. What's more suspect to me is the improvements and the money he put in. That's, if I were your settlement judge, which I can't be, but that's kind of where I would refer you to maybe Judge Weiss and say, that's really
That was, however, why we provided you for informational purposes, that PAC case. Because the PAC case, which is the 2024 unpublished Nevada Court of Appeals case, literally
Remind me.
just from 2000, literally just from last year. It's where the dealer at Wynn gets romantically involved with a foreign national from another country. The foreign national decides he's going to buy her house in Summerlin. They title the house in her name because he's not a resident of the United States. Little bit different in that they actually get a mortgage. So he makes the down payment. He then pays to improve the house, and then he makes mortgage payments for her. The relationship goes sideways. He sues for unjust enrichment, and he's requesting 3 different categories of damages: the down payment, the improvements, and the mortgage payments. The argument that is made in response by the defendants is statute of frauds. I'm on title, basically the same argument we've heard here. You have no interest in those. District court rejects the argument and says, no, it's an unjust enrichment claim. It's an equitable claim. Statute of frauds by its very terms does not include or preclude equitable relief claims. Enters judgment in the amount of $240,000, which covers all 3 of those categories of damages. It's appealed to the Court of Appeals, and the Court of Appeals says, yes, no, that's correct. The statute of frauds has nothing to do with equitable claims for relief. And affirms the decision, the judgment for $240,000. So we included that specifically because I heard you loud and clear when we were here last time, and you had said your inclination would be, maybe the purchase of the house, no, that might be barred by the statute of frauds, but the improvements, that would be something.
But it's not even just the statute of frauds. It's less everything else too. It's earlier in the relationship. There's a whole lot else going on that I don't think ultimately, when you buy someone a house, unless you're a foreign national, you can't buy your own house and live in your own house, you stay on a mortgage. You're buying, gift someone a house. And you know.
I do, and that's specifically why the word gift is not used one time in our complaint.
I know, but it feels gifty.
And I'm
Just
gonna quote the
saying.
court using the term gifty as an adjective, because that's certainly what it was. I would say 2 things in response to that, Your Honor. Number 1, I think it's important that there be clarification as to the limitation of what the damages are, because that is going to govern the scope of discovery, as this court knows. And if it's going to be a matter about the home and home improvements, then that will certainly help both parties be more efficient.
I think you've all agreed on that, right? Home and home improvements.
I think that's the focus, Your Honor. And I do understand that our complaint talks about everything. We had to show the breadth of that relationship to try to explain to the court, how this, what we describe as a long con could occur. But I do believe in terms of the recovery, what we're focusing on is the house. And again, what I've heard the court say is we are going to deny the motion, but you're granting our counter motion for leave to amend with the agreement that what we're going to do is we're going to remove the fiduciary duty claim.
Yes.
We're going to remove the aiding and abetting fiduciary duty, and instead we are going to replace those with breach of the duties flowing from a confidential relationship and aiding and abetting the breach of the duties flowing from a confidential relationship. And I will check our wherefore paragraph to see if I can provide. I'm not comfortable taking my 29-page complaint and making it a 5-page complaint, but I will certainly look at my wherefore paragraph to see if we can focus more on the house.
And I appreciate that, Judge. And the final thing I would say is the PAC decision that was submitted and cited by plaintiff was an unpublished Court of Appeals decision prior to NRAP 36 being amended to allow for the citation. More importantly, Your Honor, I think this is illustrative of my earlier argument. When the Court of Appeals affirmed the award of damages for the purpose of unjust enrichment, the Court of Appeals also recognized that there wasn't a constructed trust that had been awarded by the district court, which was also affirmed. Why was that, Judge? Because there was no confidential fiduciary relationship at the time. So again, just food for thought, Your Honor. I think we're going to be seeing more of the court as discovery progresses in this matter. But I understand the court's ruling, and we're happy to move
I
forward.
don't really think you're gonna be seeing more. I mean, I think you're gonna go talk to somebody and we're gonna see a lot less, but that's what I think.
Hope springs eternal.
Your Honor, can we agree that we can submit a very simple kind of 2-sentence order, which obviously I'll run by Mr. Jimmerson. We don't need any kind of detailed issues here. We'll provide, it's not going to take, I actually had checked on it. I think we're gonna change about 13 words in the complaint to file the amended complaint. So we can get that on file relatively
Whatever you
quickly.
guys agreed to was fine with me.
Rule 52 does not require any express findings on a motion to dismiss matter. We certainly are not going to insist on it. We're just going to stay careful about what's happening and the obvious limitation concerning the home and the approvals thereon, Judge.
Well, but let's make clear, it's not that the court has entered a ruling related to the limitations on
No,
the
nobody's
scope
filed
of
anything
damages.
for me to rule
Correct.
on. But the record, obviously, you guys have agreed that we're only talking house and improvements.
Right. And I am saying that when amending the complaint, will review the wherefore paragraph to see if I can tighten that up to give you some level of comfort.
And I appreciate that, Judge, and obviously just for the purpose of the discovery commissioner who's not heard from either of the parties yet going forward. That's all, Judge.
Okay.
All right. Thank you, Your Honor.
Thank you, Your Honor.
Thank you. Have a good day, guys.